Okay, so welcome to the deep dive. And, as always, we have a really interesting set of documents that someone has given us. And our goal is to kind of boil it down into like the most important stuff and make sure you come away feeling super informed about whatever it is. And today, that is diving into state-level healthcare information privacy laws in the U.S. Some kind of mouthful there.
Yeah.
But, it's something that I think people are increasingly aware of, that there's, the federal HIPAA regulations that most people know about, but then each state kind of layers on its own set of rules and regulations, and it gets really confusing.
Oh, for sure.
And so we're going to kind of unpack that today based on a really great 50-state survey that you shared with us, among other things. And, I know you're someone who wants to know this stuff cold, but you also don't want to have to like wade through, hundreds of pages of legalese to do it.
Right.
And that's why we're here.
Exactly. Yeah.
And before we get into it, I do want to thank the sponsors who make this deep dive possible. First off, Global Compliance Map, if you're trying to sort of map out the earth-shifting regulatory landscape, their interactive compliance mapping at www.globalcompliancemap.com is an absolutely incredible tool.
Yeah, it's a great resource.
And then also we want to thank CISO Marketplace at www.csonomarketplace.services. If you need to find some good offensive security folks, they are the place to go for that.
For sure.
Okay. So with that said, let's get into it. You were saying before we started recording that this is really sort of a hot topic right now. This whole idea of state level versus federal privacy laws.
Oh, yeah. It's a huge area. And I think, like you said, everyone knows about HIPAA at the federal level. But what's really interesting right now is all the activity that's happening at the state level. And this 50-state survey you gave me really shows how much states are driving this whole privacy conversation now, especially when it comes to health information, which is, obviously super sensitive.
Right. And it seems like this focus on state level privacy is sort of happening as part of a bigger trend, right? It's not just in a vacuum.
Yeah, exactly. I mean, if you kind of zoom out a little bit, you can see that states are getting way more involved in tech policy across the board. Like, think about all the emphasis on consumer rights when it comes to personal data. The right to delete, for example, is becoming a big deal in a lot of states. It shows how much more control people want over their own information.
Yeah, and it's not just about health data either. We've seen a ton of attention recently on protecting super sensitive stuff like reproductive health data and even location data. I think our sources mentioned that almost 20 states have actually passed what are called shield laws specifically to protect this kind of information.
So 19, to be exact. They've put these shield laws in place to prevent other states from trying to access this data. And it really shows how different states are approaching privacy in their own way. And, it's not even just privacy. States are tackling other big tech issues, too, like regulating AI, expanding broadband access, even the right to repair movement for electronics. It's like they're trying to get ahead of all these big changes that are happening in the digital world.
So it's a really active area with lots of moving pieces. And to get back to the 50-state survey from Seafarth Shaw, It seems like the whole point of this survey was to really shed some light on all these state-level regulations that go above and beyond what's in HIPAA.
Exactly. There's a lot of information out there about HIPAA, but when it comes to state laws, it's not as straightforward, and this survey is really helpful for getting a handle on that. But, it's important to remember, this is just a starting point. If you have a specific legal question, you need to talk to a lawyer.
Well, so one of the big things this survey looks at is how different states actually define protected health information, or PHI, and who they consider to be a covered entity under their laws. And it sounds like it's a real mixed bag.
Yeah, it really is a patchwork. You have some states like Alabama, Arizona, Massachusetts, and Maryland that basically stick to the HIPAA definitions or don't really go much beyond that. So in those states, things are a little more aligned with the federal standard.
So those are relatively consistent, at least in terms of definition. But then you have California, which, as always, likes to do things a little bit differently.
Right. California is interesting because their approach is so broad. They have the California Consumer Privacy Act, or CCPA, which has been updated by the California Privacy Rights Act, or CPRA, and they define personal information very, very broadly, and that definitely includes any kind of health-related data. And on top of that, they have separate definitions in other parts of their laws, like Sections 56 and 5 through 28 of the California Civil Code that deal specifically with medical information. And even their definition of a business that has to follow CCPA isn't just about healthcare providers. It's based on all sorts of criteria, like how much data they process and their revenue. So it casts a much wider net.
So in California, way more organizations and types of data fall under these privacy regulations. So it's stricter in a way.
Yeah.
What about Colorado? How do they handle it?
Colorado's kind of interesting because they don't actually define protected health information the same way IPAWA does. They have their own law, the Colorado Privacy Act, and it defines personal information, which includes medical information, so it's broad, but different terminology. And their idea of who has to follow the rules is also different. Anyone who processes personal data in Colorado has to follow their Privacy Act. It doesn't matter if they're in healthcare or not. It's all about what they do with the data.
So it's similar to California in terms of the types of data covered, but a different way of defining who's responsible what about Connecticut.
Connecticut is very specific. They lay everything out in their insurance statutes for PHI. They talk about individually identifiable health information that's kept or shared electronically or in any other way. And when it comes to covered entities, they actually point to the federal definition in their law, which mostly includes federally qualified health centers and groups that get certain grants. So it's more targeted to specific kinds of healthcare providers.
So you really can't assume anything going from state to state. What about Delaware?
Delaware is interesting because they don't have a specific definition of protected health information like HIPAA does, but their data breach notification law covers a very broad definition of personal information, and anyone who owns licenses or manages that information has to follow the rules. Yeah. So even if they don't say PHI, health information is definitely included in those breach notification requirements.
It seems like if you're operating in multiple states, this must be a real headache to keep track of all these differences.
Oh, absolutely.
And then there are states like Idaho and Mississippi that seem to take a totally different approach.
Yeah, so Idaho and Mississippi don't have a big overarching state law like HIPAA or like some of these other privacy laws we've been talking about. Instead, they deal with privacy in separate laws that are about specific types of organizations or health conditions. So it's much more piecemeal and less about having these big definitions of PHI and covered entities.
And then you have even more variation. Kentucky defines PHI very narrowly, just as STD-related information, and their covered entities are government agencies and third parties that work with them on STD-related stuff. Michigan focuses on health facilities and medical record companies. Minnesota defines covered entities super broadly as anyone who provides any kind of healthcare service. It's all over the map.
It really is, and it shows how important it is to know the specific laws in each state. Nevada, for instance, doesn't define PHI generally, but their breach notification rules apply to any data collector, which could easily include someone handling health information. New Hampshire focuses on licensed healthcare places. New Jersey often relies on making sure you have a HIPAA compliant release or a court order to share health information. New York has a whole section in their public health law that spells out exactly who counts as a covered entity. It's a real spectrum of approaches.
It's amazing Oregon defines PHI, and then they have these specific groups that are covered entities, like state health plans, insurers, healthcare providers who share information electronically, and clearinghouses. Pennsylvania and Rhode Island both define PHI, and their breach notification laws apply to anyone with personal information, which would include health data. South Carolina and South Dakota define personal information in a way that includes HIPAA's definition of health information, and their covered entities are basically anyone doing business in the state who owns or licenses this data. Texas doesn't specifically define PHI in their general laws, but health information is definitely covered, and their definition of covered entities is pretty broad. Utah and Wyoming define personal information to include health information, and their disclosure laws apply to anyone doing business in the state who has that information. Vermont specifically talks about business associates, using the same definition as HIPAA, and they have rules about disclosing health information without HIPAA-level permission. Virginia also defines protected health information by basically saying it's whatever HIPAA says it is, but their rules for breach notification can be different depending on whether you're a HIPAA-covered entity or not. And then Washington has its own My Health, My Data Act that covers consumer health data and applies to regulated entities, which have their own specific definitions. It's a lot to keep track of.
It really is.
And speaking of keeping track of things, a quick thank you to Global Compliance Map at www.globalcompliancemap.com. Their interactive compliance mapping can be a lifesaver when you're trying to untangle all these state and federal regulations.
Yeah, for sure.
Okay, so we've talked about how states define PHI and covered entities, but the Seafarth-Shaw survey also mentions that some states actually go a step further than IPI and have extra security requirements.
Exactly. It's not enough to just meet the federal requirements in some places.
Like where, for example?
Well, the survey specifically mentions Delaware, Michigan, and Minnesota as having these extra layers of security for handling personal information, including health information. So it might be things like specific technical safeguards or administrative procedures that go beyond what IPI lays out.
Interesting. And what about rules for business associates? The companies that work with covered entities and have access to PHI, are those different state by state too?
Oh, yeah, absolutely. For example, Kentucky, New York, Oregon, and Vermont all have specific rules for business associates. Often they're similar to the HEPA requirements for business associate agreements, but they can also have their own little twists or extra responsibilities. Like Kentucky says that if a third party has a contract to work with the government on STD-related information, they have to meet basically the same standards as the government agency itself. And New York has this term authorized third party, which includes anyone who has a HAPA business associate agreement. So those HIPAA obligations basically carry over to state law in certain situations.
Okay, so it's not just about who's covered. It's also about how they have to handle the information. And another thing that seems really important is what actually counts as a breach, like an unauthorized disclosure of health information. Does that definition even vary from state to state?
Yeah, you'd think that would be pretty clear-cut, but it's not always the case. I mean, usually it's about someone getting access to data they shouldn't have, but the specifics and when you have to report it can be different. Alabama, Nevada, Pennsylvania, and Wyoming are some states where a breach is basically about unauthorized access to information, but what exactly counts as unauthorized and when you have to tell people can vary.
Right. And then there are all these exceptions and safe harbors, like times when you can share information without actually getting permission from the person. Can you talk about some of those?
Sure, those are actually really important because they let the healthcare system and other legitimate things function properly. For example, Alabama and Arizona have rules about how to handle subpoenas for health information. Maryland has mandatory disclosure rules in certain public health emergencies. Massachusetts courts have developed rules about implied consent in some healthcare settings. Michigan has exceptions for sharing information related to treatment, payment, and healthcare operations, kind of like HAPO, but not exactly. Minnesota has specific authorizations for certain types of disclosures. Mississippi has exceptions for things like insurance functions and preventing crime. Nevada has guidelines for sharing information between agencies in specific cases. New Hampshire has laws about the physician-patient privilege, and when it applies, New York lets you share information with authorized third parties, which we talked about earlier. Texas has rules for responding to subpoenas. Vermont allows disclosures if there's a serious risk of harm to someone. Texas has specific rules for responding to subpoenas, and Vermont allows disclosure if there's a serious risk of danger to someone. All these exceptions show how we try to balance protecting privacy with making sure information can be shared when it needs to be.
So even within one state, there could be a lot of very specific rules about when you can and can't share information. What about the actual forms you need to get authorization? Are those standard across states?
Not necessarily. Maryland requires written authorization. Michigan wants written authorization and has specific rules for sharing a deceased person's records. Texas lets you do written, electronic, or even oral authorization as long as you document the oral consent properly. And Virginia actually has a sample form you can use to get authorization to release health information. So again, lots of variation.
So much variation. It's amazing. And to wrap up this initial look at the survey, what about reporting and remediation requirements? If there is a data breach, it seems like states are taking this stuff very seriously.
Oh, yeah. States have all sorts of rules about notifying people and regulators when there's a breach of personal information, including health information. Alabama makes you tell the Attorney General in certain cases. Arizona has penalties for violating their data breach notification law. California is very strict about breach notification. You have to tell people what happened. And when Delaware also requires notification to both individuals, and the Attorney General, Illinois, has penalties for data collectors and violations related to mental health records. Maryland is kind of unusual in that they don't have specific laws beyond IPO in this area. Michigan requires notification if unencrypted or unredacted personal information is accessed to validate. Nevada has rules about how and when you have to notify people. New Hampshire has notification requirements for breaches that involve marketing or fundraising lists if they're not in line with state law. Pennsylvania requires you to notify affected individuals. South Carolina has fines for violating their data security breach notification law, and South Dakota's definition of a breach specifically includes health information. Texas has very detailed notification rules, and they'll penalize you if you don't report breaches properly. Virginia has specific rules about how you have to notify people, and Wyoming's definition of a breach also includes unauthorized access to or use of health information. It's clear that states are really paying attention to how personal health information is protected and what happens when something goes wrong.
Absolutely.
Yeah.
So this initial look at the Seafarth-Shaw survey really shows how complicated and varied all these state-level privacy laws are. It's definitely not just a matter of following a high pay and then tacking on a few state rules.
Nope, not at all.
And speaking of extra layers of security, a big thank you to CISO Marketplace. If you're looking to make sure your organization is as secure as possible, Remember that CISO Marketplace at www.cisomarketplace.services is your trusted resource for finding vetted offensive security providers.
Absolutely.
Okay, so we've talked about these very state-specific rules, but now let's look at some of the bigger, more comprehensive state privacy laws that affect health data, even for companies that might not be fully covered by HIPAA.
Yeah.
I'm talking about laws like the Colorado Privacy Act and the Virginia Consumer Data Protection Act.
Right. These laws are much broader. They're not just about health information, but they definitely include it.
So let's start with Colorado's law, the CPA. What are some of the key things about it that are relevant to our discussion today?
One of the big things about the CPA is how much emphasis they put on consent. They say you have to get clear permission from people before you process sensitive data, which includes health information. And you also need permission if you're going to use their data for something new that's not related to why you collected it in the first place, or if you're going to do targeted advertising or sell their data after they've told you they don't want you to. And they're very specific about what counts as real consent. It has to be freely given, specific, informed, and unambiguous. So just accepting some general terms and conditions or passively clicking on something on a website doesn't cut it.
So they've set a pretty high bar for what counts as consent, and who exactly does the CPA apply to who is considered a consumer under this law?
Well, the CPA defines a consumer in a pretty specific way. It's someone who lives in Colorado and they're acting just as a regular person, not as part of a business or as an employee. And it also doesn't include people who are applying for jobs or people who are benefiting from someone's employment. So it's really focused on individuals in their private lives.
So it's about protecting people as individuals, not in their work roles. And what about the companies that have to follow the CPA, who are the controllers and processors?
The CPA separates those two. Controllers are the ones who decide why and how personal data is being used, and processors are the ones who actually work with the data on behalf of a controller. So processors have to follow the controller's instructions, and they have to help the controller follow all the rules of the CPA. And it's possible for a healthcare company to be both a controller and a processor, depending on what data they have and how they're using it.
And what about enforcing the CPA? Can people sue companies if they think their rights have been violated?
Actually, no. The Colorado Privacy Act doesn't give individuals the right to sue. Only the Attorney General and district attorneys can enforce it. However, there is this kind of grace period until January 1st, 2025, where if the Attorney General or a district attorney finds a violation that can be fixed, they have to give the company 60 days to fix it before they can take any action. But after January 1st, 2025, that grace period goes away, and they have a lot more leeway to go after companies, even if the violation could be fixed.
Interesting. And what kind of penalties could companies face if they break the rules after that grace period ends?
The law itself doesn't say exactly how much they could be fined, but it gives the Attorney General the power to set those rules, and that includes the technical details for how these universal opt-out mechanisms will work, which, like we said, will be mandatory starting January 1st, 2025. They've been working on those regulations, so the exact details about enforcement and penalties are still being figured out.
Got it. So let's switch gears and talk about Virginia. They have their own comprehensive privacy law, the Consumer Data Protection Act, or CDPA. How does that compare to Colorado's law, particularly when it comes to health information?
Virginia's law is interesting because they actually define terms that are very specific to healthcare, like health record and healthcare provider. And they often use definitions that are already in other Virginia laws, and they also use the HIPAA definition of protected health information. So they're very directly tied to the healthcare world in a way that Colorado's law might not be.
So Virginia's law has a more clear connection to existing healthcare rules. What kind of rights does the CDPA give to people in Virginia?
It gives them a bunch of rights that are pretty standard in these state privacy laws, things like the right to see their own data, the right to correct any mistakes, the right to have their data deleted, and the right to say no to their data being used for targeted advertising or being sold or for any kind of profiling that could lead to big decisions being made about them.
And what about the companies that have the data? What do they have to do under the CDPA?
They have a few key obligations they have to write clear privacy notices that explain what data they collect, how they use it, how people can exercise their rights under the law, and who they share data with. They also have to set up secure ways for people to request to exercise their rights, and they have to do data protection assessments for certain activities that are seen as higher risk, like targeted advertising and selling data.
Okay, and does the CDPA have any exemptions that are particularly important for healthcare companies?
Yeah, definitely. It specifically says that it doesn't apply to HIPAA-covered entities and to health information that's already covered by HIPAA. So that's a big difference from Colorado's law, where the connection to HIPAA isn't as clear-cut.
So while both Colorado and Virginia have these big privacy laws, they handle the overlap with HIPAA a bit differently. And now let's talk about Connecticut. Their Data Privacy Act went into effect last year, and the Attorney General just released a report about how it's going so far.
Yeah, that report is really interesting. It gives us a good early look at how the law is being interpreted and enforced.
What were some of the key findings or areas of focus in the report?
Well, they mostly focused on explaining the basic rights that people in Connecticut have under the law and what businesses have to do, which are similar to the other laws we've talked about, like the right to access, correct, and delete data and the right to opt out of targeted advertising and data sales. But one thing they really emphasized was the requirement for companies to recognize universal opt-out signals, which starts in 2025. They see that as a really important step in making it easier for people to control their data.
It seems like the Attorney General in Connecticut is already pretty actively enforcing the law, even though it's new.
Oh, yeah, very active. They sent out over a dozen notices to companies in the first 6 months that the law was in effect, basically telling them they might be violating the law. And those notices focused on things like the company's privacy policies, how they were handling sensitive data, and what they were doing with data from teenagers. The report says that most of the companies did fix the problems, but they all needed some follow-up from the Attorney General's office to make sure they were fully compliant.
What were some of the common problems they were finding in these privacy policies?
Lots of things. Some companies didn't say anything at all about the rights people have under the law. Some had vague or confusing explanations. Some made it sound like people would have to pay a fee to exercise their rights. Some didn't have clear links to opt out of data sales or targeted advertising. Some made it really hard to actually make a request, and some even had broken links in their privacy policies. And these problems weren't limited to one industry. They saw it in retail fitness tech companies focused on parenting all over the place.
So a lot of the early enforcement has been about making sure companies are being transparent and making it easy for people to exercise their rights. And the report also mentioned some confusion about how the law applies to targeted advertising aimed at teenagers.
Right. The law says you can't do targeted advertising or sell the data of kids between 13 and 15 if you know how old they are, and you ignore that. But the way it's written has caused some confusion, especially about whether you can get consent to do targeted advertising to that age group. The Attorney General has suggested that the legislature clarify this because earlier versions of the law treated data sales and targeted advertising the same way for younger people. They both required opt-in consent.
That's a good point. And the report also talked about how publicly available information isn't covered by the Connecticut law.
Yeah, they specifically say that publicly available information isn't personal data. And that includes information you can get from government records and anything the company reasonably believes the person has shared publicly. But the Attorney General is worried that this definition is too broad and could weaken the law's protections if it's not interpreted carefully.
Interesting. So the Connecticut report offers some good lessons and points out areas where state privacy laws could be improved. And speaking of improvement and staying up to date, I want to thank Global Compliance Map at www.globalcompliancemap.com. Their interactive compliance mapping tools are a fantastic resource for understanding these complex and constantly changing regulations.
They're great tools.
Okay, so we've looked at some specific laws now. Let's talk about some bigger trends and what we might see in the future with state privacy laws. This is definitely an area that's not slowing down.
Oh, absolutely. There's so much happening right now.
One trend that seems to be picking up steam is this idea of making it easier for people to delete their data. The California Delete Act is a great example of that. Can you tell us more about that?
Sure. So the California Delete Act was passed last year, and the big idea is to create a one-stop shop for people who want to delete their information from data brokers. So instead of having to contact each data broker separately, people can submit a single request through a central platform, and it gets sent to all the registered data brokers, and other states are starting to follow suit. Nebraska has a bill that's based on California's law. It's a sign that people really want to make it simpler to control their data.
That makes a lot of sense. It's about empowering people. And we're also seeing more enforcement activity from state regulators, aren't we?
Oh, yeah, for sure. As more state privacy laws take effect and as regulators get more experience, we're seeing more investigations, more complaints being taken seriously, and more enforcement actions against companies that are breaking the rules. And there's even more coordination between different states' attorneys general, and sometimes they'll refer cases to each other. It shows how seriously they're taking privacy now.
So it seems like being compliant isn't just about avoiding fines anymore. It's becoming a way for businesses to stand out and gain trust.
Exactly. As people learn more about privacy and become more careful about their data, companies that are really committed to privacy and doing things right can actually build stronger relationships with their customers. It's not just about following the law, it's about doing the right thing.
And it's worth mentioning that 2025 is going to be another big year for privacy laws, with new ones taking effect and existing ones getting updated.
That's right. Tennessee's new law will be starting, and the laws in Colorado and Connecticut will have new rules and features like that mandatory recognition of universal opt-out signals. So if your company handles personal data, especially across state lines, you need to stay on top of all these changes.
Absolutely. And speaking of staying on top of things, a final thank you to CISO Marketplace at www.cisomarketplace.services. If you need help making sure your data is secure, they can connect you with some top-notch offensive security experts.
Yeah, they're a great resource.
So we've really gone deep today into the complex world of state health information privacy laws. And if there's one big takeaway, it's that you can't just rely on IPAGAR. You have to understand the specific laws in each state.
Exactly.
We've seen how differently states define protected health information and who has to follow the rules. We've talked about the extra security requirements in some states, the different rules for data breaches, and the growing importance of these big state privacy laws like the ones in Colorado, Virginia, and Connecticut.
And I think the biggest takeaway is that it's really complicated, all these different definitions and exceptions and enforcement mechanisms. It's a lot for individuals to understand and a lot for companies to keep track of.
Absolutely. So for you listening, I really encourage you to think about how these state-level differences might affect your own health data privacy, especially if you live in or interact with companies in different states.
It's a good point, and it brings up a really important question. With all these different laws and rules, how can individuals and companies actually make sure they're protecting health information and following the law? It's going to be a big challenge for all of us going forward.
Definitely. Well, thank you so much for joining us on this deep dive into state health information privacy laws. It's a tough topic, but hopefully this has made things a little bit clearer.
You're welcome.
And a final thank you to our sponsors who make this deep dive possible. Global Compliance Map. You can find their amazing interactive compliance mapping tool at www.globalcompliancemap.com. And CISO Marketplace, your source for thoroughly vetted offensive security providers at www.cisomarketplace.services. Join us next time for another deep dive into the things you care about most.
See you then.